Good morning to all of you. Welcome to Legal Matters by Sai Baba Sunkara. In this case, in this video, I am going to tell you a beautiful case law by the Supreme Court regarding the agreement to sell. Normally we call it as agreement ATS or agreement to sale. So please remember, the agreement to sale does not confer the ownership or the title over the property. When it will come only after due registration before the sub-registrar office. This is all of you know, but still a complication has come. That's why this case law. You can read the case law as Munishwamappa versus M.Rama, reddy and others in civil appeal number 10327 by 2011, decided on 3rd November of this year. 1 minute, tell me the date correctly. Let me tell the date. On 2nd November 2023. So let us know what is this case and how things have transpired. So this Munishwamappa and Ram Reddy, the dispute is between them. What happened is, this Ram Reddy, this is going way back to 28/5/1990, 28/5/1990, wherein the appellant, that is Munishwamappa and Ram Reddy and others, they entered into an agreement of sale of a certain property which was valued at rupees 23,000 at that particular point of time. Here, the important point to note is that the respondents received the entire sale money, transaction money, that is 20,000. 23,000 was taken by them. And they have handed over the physical possession of the particular site to the appellants. So one party literally purchased it, that's all. But they did not get it registered. But there is a litigation. Why they did not get it registered? Because it was barred by the Fragmentation Act of Karnataka state. So please remember, at the time in 1990, actually, there was a prohibition on the sale as per section 5 of the Prevention of Fragmentation and Consolidation of Holdings Act 1996. So the property should not be fragmented, divided and disposed like that. There is a ban. This is the act which has come into force as 1996, right? But they know that this act will be repealed. The act will be repealed. But since the act was in force in 1990, they did not get it registered. Without registration, everything was done. Now, after 1991, the act was repealed. Now they are ready to pay the so-called amount, other things, but the party is not ready. Now they have given a go-by. Normally, as you know, when once you get the land, once you have given possession, normally you should go to the sub-registrar office or SRO and hand over the possession or write the agreement, write the registered sale deed or execute the registered sale deed. But they did not do so. Because since the so-called act has been repealed, now the agreement to sell is not valid. They know that. Anyway, these people waited for some time up to, I think, 2011. They waited almost for 10 years. Then they instituted a civil suit. The trial court dismissed the same because as per the Fragmentation Act at the time, it was not applicable. So the so-called register, the so-called agreement to sell is not valid. Then they approached the High Court. High Court has allowed the appeal. They said, no doubt, the trial court also said the limitation period is over. But of course, since it has come to their notice lately, the High Court has allowed the appeal. Now, against the order of the High Court, the matter has come before the Supreme Court. So, Honorable Judges Vikramnath and Rajesh Bindal, please remember, they held that agreement of sale or agreement to sell, ATS we have to say correct, agreement to sell is not a conveyance. It does not transfer the ownership and confers any title over the other person. Right? Even though you are in physical position, when the agreement to sell is not properly registered, then it is not deemed to be a conveyance. Students, as students you know, there is a separate semester, total semester you are going to discuss on DPC, drafting, pleading and conveyancing. At the time you will know what is conveyance. Right? So please remember, the Supreme Court noted that the bar under Section 5 of the Fragmentation Act was the bar or it was the hurdle for the transfer of rights. Right? Now, the act has been repealed. These people have been in physical possession. So therefore, basing on the powers, inherent powers of the Supreme Court, the court ordered the so-called respondents to register the land in favor of the appellant. This is what is called justice. Justice was done to the parties. But the important legal point you have to know is agreement to sell does not confer any right or title over the property. This is more important. Please read the case law and enrich your legal knowledge. With this, I am concluding. Thank you very much.